Thank you, Mr. President. Would the very distinguished sponsor yield to several set of questions?
With pleasure, Mr. President.
Thank you. I'd like to begin with the title of the subject bill. The title is an act amending Batas Pambansa Bilang 68 of the Corporation Code of the Philippines. We know that there are several bills on this matter and they were consolidated, and now we have a consolidated substitute bill. May we be enlightened, Mr. President, as to why the committee, through the good sponsor, opted to style it as an act amending instead of an act revising the corporation code?
There is no particular consideration for using the phrase amending, but for the information of the body, Mr. President, what we intend to do is during the period of committee amendment, we will submit the bill containing all the sections which are not revised, so that hence if we pass the law, then it will be only one continuous bill, and we propose to entitle it the Revised Corporation Code of the Philippines. And I would repeat, we would incorporate all the unamended portions of the present Batas Pambansa Bilang 68.
So the intent, Mr. President, is that the end product of this consolidated substitute bill would actually be a revised corporation code and
Yes.
not amended.
Yes, Mr. President, considering the extensive amendment
Yes.
that is being introduced.
Exactly, Mr. President. That's why I had to ask that, because it's either these are amendments or revision. And when we say revision, this covers substantial and extensive changes. Although the proposed measure does not intend to overhaul or does not seek to overhaul the entire code, but there are quite a number of provisions that are affected.
That is correct, Mr. President. That's why we, as we said, at the appropriate time after the period of interpellations, when we introduce the committee amendments, we will incorporate as committee amendments the adoption of the sections in the present Batas Pambansa Bilang 68 which are not amended, so that the end product will be a Republic Act, once we have passed this Republic Act number so and so, and we repeals Batas Pambansa Bilang 68 in its entirety.
Thank you. On the qualifications of incorporators, Mr. President, as the law now stands, the corporation code itself, before the proposed amendment, it expressly speaks only of natural persons as those who may form a private corporation for any lawful purpose or purposes. But as proposed to be amended by Section 4 in the measure, it will now expressly authorize, quote, any person, partnership, association, or corporation, singly or jointly with others, to, quote, organize a corporation for any lawful purpose or purposes. It further requires that a majority of such person, partnership, association, or corporation should be residents of the Philippines. My question, Mr. President, may we clarify for purposes of the code and the proposed amendments what entities are intended to be encompassed by the term associations as qualified to be incorporators?
This refers to non-profit corporations being organized. And it's referred to as association.
So are we clear, Mr. President, that one proposed amendment is in fact allow associations and corporations to be incorporators, not natural persons under the current, not just natural persons under the current law?
That's correct, Mr. President, because also as an additional information, we are allowing a one-person corporation. And a one-person corporation can be an estate.
Yes, Mr. President, and that is actually my next point. This is one of the important innovations in the proposed measure. We are now recognizing a new corporate entity called the one-person corporation.
Yes, Mr. President. One-person corporation will now be authorized under the proposed amendments that we have submitted. And the purpose of this is to allow businessmen the benefits of a corporation and not resort to, nominating your driver or whoever according to Senator Villanueva, your dummies to be incorporators or members of the corporation, when in fact it is a corporation belonging to one person. So it is recognizing present-day realities. That's one. Number two, OPCs, or one-person corporations, are recognized worldwide. And there is certainly no strong policy objections to having a one-person corporation in our country. It is part of our effort to allow or to enhance the ease of doing business in our country.
We do recognize the wisdom in introducing behind this amendment to introduce this new corporate vehicle called one-person corporation, one incorporator, sole stockholder, but subject to the limitation that an individual may only incorporate a single one-person corporation.
That limitation.
Not anymore. We remove that.
We remove that, Mr. President. In other words, there is no limit as to the number of OPCs that one may avail of.
May we know, Mr. President, the rationale for that? The original proposal is to impose that limitation, that an individual may only incorporate a single OPC, and I understand that that limitation. So why the change, Mr. President?
Well, we are removing that limitation in recognition of the fact that a single individual may engage in several kinds of businesses. So that if you limit them to only one corporation, then you try to liberalize on one hand doing business through the corporate entity, and on the other hand restrict the ability to avail of that convenience by restricting it just to one field of business. We thought that since this is for the purpose of enhancing the environment so that we can do, so we can enhance doing business, we remove that restriction.
So no limit.
Yes.
Is a one-person corporation whose single stockholder is a natural person entitled to avail of the option electing to have a perpetual existence? Again, that's one of the innovations.
Yes.
That corporations now can have a perpetual term, not subject to renewal.
That's correct, Mr. President. An OPC can have or a one-person corporation can have a perpetual existence.
The policy considerations if I'm not mistaken, Mr. President, that were used or being used to justify the grant of such option to ordinary corporations, I would like to believe, do not apply to one-person corporation. Because, number one, precisely it has the same director, president, and stockholder throughout its existence. Hence, the changing of such officers resulting in the ability to keep track of the expiration date does not apply. I think that's one of the rationale for this one person, for the perpetual term, for the introduction of the concept of perpetual term for all corporations. And the good sponsor just said that that would also apply to one person corporation, and also because it is quite unlikely that the same single stockholder of an one-person corporation would be able to manage the affairs of the corporation as its sole director and president for more than 50 years. And in any case, in the case of his incapacity or death, there are procedures that still need to be followed, regardless of whether he or she would have opted for a perpetual existence. I just would want to understand why OPC, or one-person corporation, is also being granted the option to avail of the perpetual term rule.
Well, precisely, we allow the OPCs to enable a businessman to avail of the corporate vehicle to conduct business. As the senator from Bicol correctly said, in case of the demise of the single stockholder, there are procedures upon which the corporation, the OPC, can continue to exist initially by going to court and having the temporary corporate director or manager, nominees, and subsequently, once the estate is settled, for the heirs to be able to take over. We see no policy distinction between the corporations as it is today, which are given perpetually terms, and a one-man corporation. The purpose that is being served would be the same, to allow continuity of the entity in its corporate form, rather than be disrupted by an expiration of the term. In the view of the committee, Mr. President, the policy considerations are the same whether it is a one-person corporation or the ordinary corporation with several stockholders.
Still on the OPC, Mr. President, Section 123 states that the single stockholder shall be the sole director and president of the OPC. Section 124 requires the single stockholder, the sole director, the sole president to appoint the following officers within 15 days from the issuance of its certificate of incorporation: treasurer, corporate secretary, and other officers as it may deem necessary.
Yeah.
But the last paragraph of the same section, Section 124, specifically states that the single stockholder may not be appointed as the corporate secretary. Mr. President, distinguished sponsor, may we clarify that the express prohibition at the end of Section 124, which is a new provision, just like all the other provisions pertaining to OPC, whether that express prohibition at the end implies that the single stockholder, sole director, sole president is not prohibited from designating himself as the treasurer or any other officer of the OPC which he may deem necessary. I tend to get confused.
So the question is, there is no prohibition from the single stockholder being appointed as treasurer.
From designating himself, because he is
treasurer.
given the power to
Please,
appoint
There is, sir. You cannot appoint yourself as secretary.
treasurer, corporate secretary, other officers that may deem necessary. But I wonder why there is this section, the last paragraph
Yes.
saying that the
Yes.
single stockholder may not be appointed as the corporate secretary.
The following section, Mr. President, provides the answer. Section 125 assigns special functions to the corporate secretary, which necessitates that the single stockholder may not appoint himself as the corporate secretary. There is an enumeration of the requirements, of the requirements of the, or the functions of the corporate secretary, but we can review this, Madam President, or Mr. President.
My specific concern, Mr. President, is about the sole director, the sole stockholder, the sole incorporator, who is the president, designating himself likewise as corporate treasurer.
Well, for one, Mr. President, if you notice on paragraph 3 of section 125, the death of the stockholder must be, the commission must be notified of the death of the single stockholder. If the single stockholder is also the secretary, nobody will report anymore on the death of the single stockholder. So that's, so these are the, among the reasons why we have to make that prohibition. It's only, something that is made necessary by the very nature of the corporation.
Do I take it that with that answer of the distinguished sponsor, with that explanation of the distinguished sponsor, the answer to my question whether or not the sole director, sole president, single stockholder of the OPC may designate himself as the corporate treasurer,
Yes,
because there's no prohibition?
yes.
Wouldn't the distinguished sponsor think or consider the possibility or risk of abuse or occasions for conflicts of interest of allowing one person to hold the position of all corporate officers, save the corporate secretary, be too high, that there wouldn't be enough safeguards to preserve the interests of other stakeholders, such as the creditors of the corporation?
Okay. The single stockholder, there are certain safeguards against such abuses. The one? Okay. There are reportorial requirements, for example, which, among others, would require a disclosure of all self-dealings and related party transactions. This is part of the report that is to be submitted to the Commission as part of the safeguards against abuses that may be committed.
Thank you. So again, it's clear to us that the only other officer or position that the sole president, director, and stockholder is prohibited to designate himself is corporate secretary. All other corporate officers, he may assume the role.
That's correct, Mr. President, because of the peculiarity that there must be someone who should report the death of a single stockholder, and that is the corporate secretary. If you allow the single stockholder to appoint himself as the corporate secretary, in case of his death, his soul cannot report the death to the SEC.
Yes, we understand that, Mr. President. I'm not yet so convinced with the
Yes, we
with
try to convince Mr. President.
about why, as the sole director, sole stockholder, sole president, would be allowed to the option to appoint himself or designate himself to be all other corporate officers
Yes,
except corporate secretary.
Yes, Mr. President. This is a provision where where we can be liberal in accepting amendments, and certainly I see the valid point of the gentle lady from the Bicol, and therefore we will consider that favorably if proposed on the period of amendments.
Thank you. Doon naman po tayo sa nominee and alternate nominee you mentioned po.
Yes.
So this is again, of course, since OPC itself is a new concept insofar as our own laws are concerned, this is equally a new idea.
Yes.
Now, sections 126 and 127 of the proposed new chapter provides for the designation and term of the nominee and alternative nominee whose function is to, quote, take the place of the single stockholder as director and shall manage the corporate affairs, unquote, in the case of the death or incapacity of the single stockholder. Now, Mr. President, given the possibility that such nominee and alternate nominee will, in some, if not most instances, I'd like to surmise, be such persons that are closely related to the single stockholder. I think we can anticipate that that is exactly what would happen. Most of this would be closely, this nominee and alternate nominee would be closely related to the single stockholder. There is also a possibility, remote as it may be, that the single stockholder, the nominee and alternate nominee might pass away or become incapacitated simultaneously or close in succession to one another without any of them having the opportunity to designate another nominee to manage the corporate affairs in their stead. So my question po, if such contingency should come to pass, who will be authorized to designate the manager of the corporate affairs until the single stockholder regains capacity to resume such duties in the case of temporary capacity, or until the procedure following the death or permanent incapacity of the single stockholder as stated under the second paragraph of Article 127 has been accomplished? Of course, I'm talking about an extreme situation, but just anticipating that it could be a possibility.
Yes, you're talking about the possibility of the single stockholder and all the legal heirs dying in an airplane crash, for example, so that there is no more heir of the single stockholder to take over. In that case, I would think that the rules on succession will follow, so that whoever is the legal heir, if whoever is the legal heir left will be the one to take over as the nominee.
Thank you.
Just like if it is a single proprietorship, the business will be inherited by the legal heir. So we are just providing a corporate vehicle upon which the management of the OPC will be passed on to in case of the death of, in a calamity or in a famine, that all the heirs, all the direct heirs, for example, would die.
Thank you. I'm also very interested, Mr. President, about knowing the exact metes and bounds of the concept of limited liability as applied to the OPC. Because there is one empirical study published by Cornell Law Review. May I just quote a few material portions? The number of shareholders makes a difference in the propensity of courts to pierce the veil of corporations. Among closed corporations, those with only one shareholder were pierced in almost 50% of the cases. For 2 or 3 shareholder corporations, the percentage dropped to just over 4 to 6%. And for closed corporations with more than 3 shareholders, the percentage dropped to about 35%. The study went on to say that since the 1897 decision of the House of Lords upholding the limited liability of what was essentially a one-person corporation, courts and commentators have vigorously debated the propriety of limited liability for these enterprises. But of course, we know that the corporate vehicle is really a preferred vehicle precisely because of the applicability of the doctrine of limited liability. Now, as noted actually in a footnote of that article I cited, Mr. President, the concern arises from the fact that the, quote, peculiar opportunity for manipulation and superior knowledge of the sole shareholder, end of quote. In order to address this, it was said in that article, it is being posited in that article that it is, quote, desirable that a sole shareholder claiming limited liability affirmatively show that the corporation was adequately financed, end of quote.
Yes.
These are my questions, Mr. President. May we clarify from the distinguished sponsor whether or not it is the intent to grant the one-person corporation exactly the same nature of limited liability as ordinary corporations?
Yes, Mr. President, but we must make it very clear that the principle of piercing the corporate veil would still apply. Meaning that if it is a ground for piercing the corporate veil in cases where there are, in case of stock corporation and there are several stockholders, the same grounds would apply even in cases of OPCs. In other words, where it is where the corporation was formed for fraud or for some unlawful purpose, the fact that there is a corporate entity would not prevent the injured party from piercing that veil of corporate entity and run after the assets, personal assets of the single stockholder if so necessary. So we will repeat for the record, Mr. President, the principle of when you can pierce the corporate veil would still be maintained, and all the principles would still be applicable. And again, we decided to incorporate the OPC because this is the practice in many countries. And in this very competitive world, we have to align our laws so that we will not be placed at a disadvantage given the fact that we are disadvantaged in many areas. So we want to remove any of these obstacles. There are many countries, some of the countries with, which allows OPCs would be the United Kingdom, the EU countries. In the United States, OPCs are allowed. In Singapore, in China, in the United Arab Emirates, Turkey, Pakistan, New Zealand, India. These are some of the countries where OPCs are allowed. And as we said, we put this in order that we can be competitive with these countries, so in order to improve our investment climate, as this would ensure, we would encourage small and medium-sized enterprises to incorporate, and also would encourage entrepreneurship.
Thank you. This representation, Mr. President, in fact, is fully supportive of this innovation into our laws, introduction of this concept of OPC. I'm just a bit concerned about, and it's good to know that indeed the doctrine of the piercing of the veil of corporate entity equally applies to OPCs. Yes. Would the good sponsor be open to putting certain other safeguards? Because there is really, realistically, there is a difference between one-person corporations and ordinary corporations.
We are open to that, Mr. President. At the appropriate time, we will certainly be open to amendments which will place more safeguards.
Thank you, Mr. President. I'd like to proceed insofar as professional corporations, as to the professional corporations. May I know from the very distinguished sponsor whether a natural person who is licensed to practice a profession, example, law, medicine, accounting, architecture, is a natural person authorized to organize an OPC under the proposed amendments?
Can a professional organize into an OPC?
Yes.
Can a lawyer form a corporation for the practice of law?
Yes.
If the lawyer today cannot get 5 lawyers to form a corporation to practice law, that same prohibition will apply in cases of, that same prohibition will continuously apply, and the ability to form an OPC will not change that. In other words, it depends on the profession, on the regulatory framework of the profession, whether or not you are allowed to incorporate the practice. As a lawyer, I know that we are not allowed to incorporate our practice of law because we cannot issue shares to, although brilliant economists like Senator Ralph Recto cannot be a stockholder in a legal corporation. And the allowing the OPC will not change that.
That will not change that.
No.
So that is clear.
Yes.
Not allowed.
Not allowed.
Well, Section 10 of the code, as proposed to be amended by Section 4 in the proposed measure, will now expressly authorize, quote, any person, partnership, association, or corporation, singly or jointly with others, to organize a corporation for any lawful purpose or purposes. Now, under current laws, licensed professionals belonging to the same profession, lawyers, architects, etc., are authorized to form partnerships.
That's correct.
And
Yes.
that's what lawyers do.
Yes.
Form a partnership
Yes.
among lawyers. May we clarify whether or not, under the proposed amendments, natural persons who are licensed to practice a profession and/or partnerships or associations composed of such natural persons will be allowed to form a corporation for the purpose of the practice of such profession?
No, Mr. President, because precisely because of the limited liability in cases of corporations, a lawyer who commits a mistake would send his client to jail, if not somewhere else. But precisely the liability of the lawyer should not be limited by the limits of the liability under a corporate entity. His assets should be made answerable for his mistakes or her mistakes. And therefore, the matter of allowing professionals like lawyers to form a corporation and therefore have a limited liability is not allowed even under the amendment that we have proposed.
So even under the amendments we are proposing, we are not open, our legal regime would not be open to the formation of the so-called professional corporations?
Personally, I am not, but I'm willing to be convinced. This chairman of the SEC is a lawyer, so I do not know if she's willing to incorporate her profession so that a lawyer will have limited liability. But that will open the doors to a lot of things which
Exactly.
are uncharted, and therefore at this point, maybe we can just follow the same rule that professionals be allowed to form partnerships so that the limited liability protection in a corporation will not be available to them.
Because there are, of course, advantages and disadvantages
Yes.
for any such proposal.
But if we are going to look at it from the interest of the public,
Yes.
maybe the better rule is a partnership rather than a corporation for purposes of exercising one's profession.
Thank you, Mr. President. And I think this is my last point. Oh, let me check, because I have lots of notes. So not yet. It's not yet my last point, Mr. President, with the indulgence of the distinguished sponsor. It's about the amendment of articles of incorporation.
Yes.
First paragraph, second subparagraph
Page,
of section 8, item number 2, page 7,
Page
line
7.
23, Mr. President.
page 7, line
Line 23.
23. Yes.
I'm just a bit curious about the change, certain changes in terminologies, or the crafting perhaps. I'm not sure whether there's a good reason for the change.
This is,
It says one of the required contents of an articles of incorporation is already in the current law. The specific purpose or purposes for which the corporation is being formed. I noticed the change of the term from incorporated to form. I'm just wondering, is this something that was deliberate to change the
yes,
word?
it was deliberate, but it's a matter of style. Nothing that should change any meaning. That is not the intention. Instead, we just avoided using again corporation, which is already on line 22.
Okay, so it's just a matter of style.
That's a matter of style, yes.
First paragraph naman po, third subparagraph, page 8,
Yes.
lines 4 to 5. Again, I notice a slight change in the terminologies or the use of certain phrases from the phrase, the place where the principal office, to the specific address of the principal office of the corporation. In other words, there is a change in the language from the place where to the specific address of the principal office of the corporation. So we're still talking here, Mr. President, about the mandatory contents of the articles of incorporation. On the other hand, under the amendments proposed by Section 9, the third paragraph of Section 15 of the Corporation Code, the forms of articles of incorporation, which is the portion where the address of the principal place of business is to be stated, remains unchanged.
Yes.
I'm just again curious, Mr. President, whether the shift in the language is just nothing there. It's just a matter of style.
These are one of the amendments originally proposed that we are reviewing. And at the appropriate time, we may delete the proposed amendment because the principal place of business as stated for purposes of is stated for purposes of determining the venue of the actions and jurisdiction over the corporation for tax and other purposes. Requiring a specific address may be not consistent with the ease of doing business because it will not allow the corporation to be able to move to other premises within the same city or municipality. So we may delete that amendment at the appropriate time and submit the same to the body for their consideration.
Thank you, Mr. President. On the first paragraph, 10th subparagraph, still on the same provision, Section 14 of the new law, of the the proposed measure, it speaks of a statement of the treasurer, again as among the contents, mandatory contents of the Articles of Incorporation. May we ask that the good sponsor compare this to how the law currently stands based on the current language of the last paragraph of the same section 14, particularly page 8, lines 13 to 14, which is proposed to be deleted. Dati po, nandyan yung, or sa ngayon po, nandyan yung paragraph na yan. It says, the Securities and Exchange Commission shall not accept the Articles of Incorporation of any stock corporation unless accompanied by a sworn statement of the treasurer elected by the subscribers. So I note a difference here.
We just move that paragraph. There is no intention to amend. It is just to properly situate it as paragraph 10, so that paragraph 10 is followed by paragraph 11, which is a general statement, the general power of the SEC to include other information that they may require to be stated. There is no intention to make any substantial amendment.
Moving on, also on the same point, I'm rather getting very particular about the usage of certain terms. Now, Section 15, as proposed to be amended by Section 9, particularly the 10th paragraph, page 12, lines 1 to 4. So it refers to the treasurer that he or she certifies the information set forth in the 7th, 8th, and 9th clauses above. Now, also Section 15, as proposed to be amended by Section 9, particularly the portion for signatories at line 26, which requires only the signatures of incorporators. Section 17, the grounds when articles of incorporation or amendments may be rejected or disapproved, as proposed to be amended by Section 10, page 14, line 14, which speaks of certification in lieu of treasurer's affidavit. Notably, too, Section 9 proposes to delete the entire portion of treasurer's affidavit. Again, may I just be very particular about this? The shift is from sworn statement to certification.
Yes.
Do I have that?
The sworn statement or the certification will contain the same substance, but it is only a shift from a sworn statement to a
Certification.
from affidavit to a sworn statement, and this just places in the law the present practice. That's how it is practiced today.
So it's certification. So if it's just really the same
Yes.
concept, would I take it, Mr. President, that the certification must still be under oath?
Yes, ma'am. Yes, ma'am.
Thank you, sir. Mr. President, doon na lang po ako sa last point.
Yes. Mahirap talaga itong batas na ito, kaya pwede na po ang last point.
The very distinguished sponsor was present during the committee hearing of the
Yes.
the Committee on Electoral Reforms and People's Participation.
Yes.
We were then, this was only last week, Mr. President, we were then tackling the bills on the political party reforms and the political party system. And one of the bills actually tackled was the one sponsored by the distinguished sponsor now of the amendments to the Corporation Code. And in the course of the discussion, there were certain views aired by some of the resource persons that it's probably time to revisit the prohibition under existing laws, and I'm referring to both the Omnibus Election Code and the Corporation Code, prohibiting private corporation to make a donation. And in fact, it is here in the current Corporation Code, Section 36, Paragraph 9, among the enumeration of the powers and capacity of a private corporation is, quote, to make reasonable donations, including those for the public welfare or for hospital, charitable, cultural, scientific, civic, or similar purposes, provided that no corporation, domestic or foreign, shall give donations in aid of any political party or candidate or for purposes of partisan political activity. Now, I have no problem with respect to the prohibition as against foreign corporations. No way that we should allow that, because that is in fact a constitutional ban. But what about private corporations? Under both the Omnibus Election Code and the Corporation Code, local, domestic, foreign, domestic, private corporations. Would the distinguished gentleman propose a revisit of this prohibition?
Thank you for that question, Mr. President. And I hope our colleagues in the lounge will listen to my answer because it will benefit them. Yes, under the present state of the law, corporations are prohibited from making contributions. That's expressly prohibited. But we all know that these things happen. Maybe not expressly not in name from the corporation, but in fact it is sourced out of corporate funds. And therefore, Mr. President, again, I hope the colleagues are listening in the lounge. We are agreeable to allowing corporations, domestic corporations, to make political contributions by amending that prohibition. That prohibition should apply only to foreign corporations as proposed by the good senator from the Bicol area.
Mr. President, it is very enlightening to hear from the distinguished sponsor about his openness to consider elimination of the prohibition against donations for political purposes
Yes.
from domestic private corporations. I'm sure this is going to be a contentious matter. Definitely no question about the foreign corporations, as I said, but the domestic. I'm sure that if at all that this would be considered, I think there ought to be real safeguards also, or limitations, including the amounts. There must be a cap, and also certain conditions to be imposed. Would the distinguished
The
sponsor-
limitations of the amount of contributions and other conditions should be in the revised election code. Insofar as the corporation code is concerned, it is only a recognition that corporations may contribute to candidates. And this is a good provision, because then it will really make contributions transparent. I mean, small step, but certainly is the correct way of doing things. We should allow corporations to make contributions legally, so that they do not have to hide behind the facade that it is not the corporation doing it. We see no policy consideration, we see no adverse policy consideration by allowing corporations to make contributions. In fact, that will make it transparent, so that in case a measure comes before the floor or legislative body, those contributors or corporations immediately will be made aware that there can be possible conflicts of interest where they intervene in the passage of the law, if in fact they are contributors.
That's exactly what I meant, Mr. President, that we can consider, if we are to consider the deletion of the prohibition, then we have to really put in the necessary safeguards also.
But
because
in
of
the election code.
In the election code,
Not
not
in the
necessarily
corporation code.
in the corporation code.
Yes.
So it's good to know the views of the very distinguished sponsor on that matter, so that our committee, the Committee on Electoral Reforms and People's Participation, would also start looking into that and come up with the appropriate legislative measure. And it would be good if there would also be a parallel action from the Committee on Constitutional Amendments, beginning with this measure.
The chair has a question.
Yes. Yes, Mr. Chair.
Mr. Sponsor, is it possible to not put any limit anymore?
If there will be a limit, Mr. Chair, Mr. President, it should be in the election code. We will have no limit insofar as the corporation code is concerned. But insofar as
Election code.
the election code is concerned, that is where the limit should be appropriately indicated, because it usually is in the form of, the number of voters times a certain amount as the limit for the contribution. So it must be it must be provided in the election code, not in the corporation code, the bill which we are now debating on.
This representation agrees with that position, that it should be inputted into the omnibus election code, but I would definitely go for certain limitations on that aspect.
In the meantime, we will remove that prohibition in the corporation code, because otherwise that prohibition will get into conflict with the provision of the revised election code.
Thank you, Mr. President. Thank you, distinguished sponsor, for
Thank you.
this
Thank you
very
to
healthy
the-
exchange of views. Thank you very much.
Thank you, Senator De Lima, Majority Leader.
Thank you, Mr. President. I move to suspend the session.
Session is suspended.